Good afternoon, everybody, and welcome to this online briefing moving toward GDPR. My name's Edward Pull from the Jisc training team, and Andrew Cormack is our Chief Regulatory Advisor who's presenting the session. So without further ado, I'm going to hand over to Andrew and we will make a start.
Okay, thanks Edward, and good afternoon from me. My slides just disappeared. Welcome to this session on the moving towards general data protection regulation. I'm aiming to talk for about 40 minutes of the hour and then answer any questions you have in the remaining time to make it up to an hour. Oh, sorry Tony, loud and distorted. Oh, loud and distorted for you? Right, let's try that. Apparently you have to click OK for the application to pay attention to you. That better? Yeah, I'm getting a thumbs up here. Right, thank you. Sorry for that. I guess I must have been using some other application that needed the microphone volume up. Right, in the next 40 minutes, look at what new legislation there is around the General Data Protection Regulation, which I'll henceforward refer to as GDPR, and also the ePrivacy regulation, which has just emerged from the darker corners of the European Commission. Quick view of what the significant changes are from the existing data protection laws that we have. Some ideas that we're using within Jisc on how to approach the new regulation to try and see which of those are relevant and helpful. And then finally some organisational issues based on the Information Commissioner's 12 steps. If you've got kind of immediate questions of interpretation, I'll try and pick those up and answer them immediately, but sort of deeper, meatier questions we'll leave till later. And thanks for putting questions about technology down in the bottom box. So I'll leave Edward to answer that one. I think the answer is yes. Okay. So what we've got, the GDPR, actually the last word there is quite significant. The fact that it's a regulation, not a directive. The old 1995 data protection law was a European Union directive. A directive is an instruction to individual member states to go and do legislation that has this effect. So it's a two-step process. A regulation, however, is a one-step process that it creates law. So it is itself law which applies directly, as it says here, both to every individual in Europe. And what matters is physical presence in Europe. It's not whether you're a European national or a European citizen or whatever. It's a living, breathing person currently sitting in Europe. And it also applies to every organisation processing personal data about those individuals. One other thing that's new and maybe significant depending on how they enforce it is that the GDPR claims to also apply to organisations outside Europe that provide services to individual Europeans or that collect data about individual Europeans. So there's some new ideas there on legislation. Which we probably won't look into because I guess most of us are at least in Europe. I think there may be one or two people from outside the UK, but that's an issue for external service providers that they're suddenly going to have to look at this legislation. It replaces, I say, an older data protection directive from 1995. Being a regulation, you would anyway expect it to have a bit more detail because of this thing that it has to be law itself. But even taking that into account, it's a lot longer. Depending on how you count it, it's about 3 times longer, whether you count by articles or by pages or whatever. One of the slightly puzzling things, not puzzling things, it catches people out sometimes. It is already law. It became European law on the 25th of May 2016, last year. And so, but there was a 2-year introductory period. So it will actually come into force and become enforceable on the 25th of May next year. Would this apply to universities abroad taking students from Europe? Yes, and that's interesting from their point of view. So that's what it is. What it isn't, it's not finished, unfortunately. There are built into the regulation about 50, a bit over 50 areas where the regulation itself turns into a directive in a way and says to member states, go and make some law that suits your local conditions on this. Probably the most significant one of those two universities anyway is the whole area of research and processing personal data in research. The UK government has just published a statement of intent, which every lawyer I know is scratching their heads over, saying what actually is the legal significance of a government statement of intent. But anyway, it says that they are intending to try and preserve the existing research data protection regime from under the Data Protection Act. Whether they'll be able to do that within the constraints of the regulation, not quite clear. Probably the more significant and more wider impact issue where it's not finished is that although regulators were quite keen to tell everybody you have 2 years to implement this, 2 years isn't long. The regulators themselves have been very slow about producing guidance. So we've been told, the Information Commissioner consulted on consent, I think back in January, and they've now said they won't be publishing the final guidance until December or possibly January of next year. Similarly on privacy notices, which the European Data Protection, new term, Article 29 Working Party as they are at the moment, the group of data protection regulators have said yes, they will produce guidance, but again it won't be till December or January. So I think what we need to do on that is make the best we can. The Information Commissioner has certainly said use existing guidance, of which there is a fair bit, and hope that whatever comes out isn't too significantly different. At least the sorts of processes I'll be talking about later mean that you should be able to quickly assess whether new guidance is actually new and needs you to change something in the last 4 or 5 months. In a way, I think it almost increases the importance of getting started now and getting on with it, because we know that the last 4 or 5 months will be taken up with the detail of implementing whatever guidance comes in. One of the other problems here is a comment there about cloud services. As far as I can see, no regulator has said that they're going to provide any guidance on cloud, which is deeply unhelpful since, number one, cloud was one of the issues that was raised as why we needed new legislation, and it has caused a lot of challenges in interpreting where a cloud provider sits into existing and the new regulation. Lacking guidance on that, I think we and large cloud providers to an extent are going to have to try and guess what is intended. So that's, to my mind, unsatisfactory, but it seems to be where the regulators have left us. Then coming along, particularly if you are operating any sort of computer network or any sort of email service or application services that transmit data over networks, there's an ePrivacy regulation. At the moment we have an ePrivacy directive. A lot of what was in the ePrivacy directive actually went into the data protection regulation, but the legislators have decided that no, they still need an ePrivacy regulation. And whereas the GDPR was at least finalized text in 2016, the ePrivacy regulation was only published as a first draft for comments back in January of this year. The Commission's ambition is that that should be in force on the same date of May next year, but a number of people have expressed doubt going on, extreme doubt as to whether that's feasible. So certainly from now until May, there will still be uncertainty, I'm afraid. There is likely to be change. People may come up with interpretations we hadn't expected. After May, courts may come up with interpretations we hadn't expected. It was something, I think it was over 10 years after the Data Protection Directive when the UK House of Lords decided that personal data didn't mean what everybody thought it did. So things will change, things may well even be contradictory. So don't treat the GDPR as a fixed target, I'm afraid. You need flexibility to deal with changes that will come along. Does it cover you? Almost certainly. The definition is very broad. It covers anybody processing, which includes collecting, storing, even deleting personal data. And the definition of personal data is very wide. So it will almost certainly include most situations where you've got MAC addresses, Ethernet addresses, IP addresses. There is a fairly recent case actually under existing law, Breyer versus Germany, where it was decided that even dynamic IP addresses could be personal data in the logs of a website. RFID tags, anything with a persistent identifier is likely to be personal data. Even that may not be the full range of it. There's been suggestions that actually anything that could allow you to identify, so it doesn't have to be a single identifier, it can be a group of characteristics. And people looking at location data have discovered that I think it's if you've got 5 location points, you can come up with a pretty accurate estimate of where, of who that individual is. If you know where they live, where they work, how they travel there, you can start seeing how very quickly that could become unique to an individual. So my suggestion to avoid nasty surprises is anywhere where you've got one record equals one person, bear in mind that if that isn't personal data already, it could well become personal data. And then, as if that wasn't enough, the ePrivacy regulation includes stuff that isn't personal data quite explicitly. So it's any data relating to communications, headers, content, location data as mentioned, even if it's not personal data. So don't switch off now thinking this doesn't apply to me if you're anything to do with operating or providing network services. You're almost certainly covered by this. The regulation, the ePrivacy regulation I mentioned, published in draft by the Commission this January. That draft said public network operators, so that makes life a little easier for us because Janet and most university networks would be considered private networks. It does also, though, cover Wi-Fi and Bluetooth tracking. So I know a number of universities have been looking at what you can do with data about physical location of mobile phones and things like that. It also covers any public use of cookies in web browsers. So if your website produces cookies, you will be covered by the regulation. Web analytics, I asked about last time, is explicitly covered by the regulation. And the rule in the Commission draft was you can only process this data for the purpose of providing a service or for security, or if you've got the individual user's consent, which is much narrower. That eliminates effectively 3 or 4 of the reasons that the GDPR itself gives you for processing personal data. So, tight regulation. However, the European legislative process involves 3 organisations, the European Commission, the European Parliament, and the European Council of Ministers. It doesn't formally include the regulators, but in April, the Article 29 group of European data protection regulators and the European Data Protection Supervisor, who is the regulator for the EU bodies, published effectively suggestions, comments on the draft. They suggested adding because they felt there were equal privacy issues, hospitals, hotels and universities. So, this could be directly applicable to us as well. I was looking at the next stage, we'll get to the European Parliament's amendment, suggested amendment, and they haven't picked up on that. So they have not extended it to cover universities. So we seem to be right on the borderline of whether we're going to be included or not. The regulators also said add anyone processing the same data, which is sort of logical because otherwise you could just outsource your processing to them. But if anybody processing an IP address has to comply with this ePrivacy regulation, then the privacy regulation simply isn't going to work because it makes lots of assumptions about you are a communications provider. So the formal stages are for the European Parliament and for the Council of Ministers to have a look at it and to propose amendments. They've sort of started on that before they went on their summer holidays. Council of Ministers said, and this is a quote, that the aim to have it enforced by May 2018 was unrealistic. So they're not very positive about it. The European Parliament, actually this is as of last week, slightly out of date. As of last week they'd published 800 amendments. I think it's over 400 pages now of amendments they'd like to see to it, and the Parliament will be voting on that fairly soon when they come back in the autumn, and they will then aim to come up with a Parliament agreed version. The Council of Ministers one day will come up with a Council of Ministers agreed version, and then the three get together to try and agree on a common text. So chances of this being enforced by May, very small. But it's out there. It will, certainly the cookie provision, the Wi-Fi Bluetooth stuff will apply to us. Whether the actual network stuff will, I'm not sure. Still to be decided. So back at the GDPR itself, my kind of short flight of stairs summary of what is the difference is that under the Data Protection Directive, you were asked to think about what personal data are we processing. So we all went round and we made lists of, well, we looked at computers, we looked at disks, and we found personal data and we made lists of it. The GDPR, I think, asks us to do more, because rather than just what personal data we've got, it says why. And that may or may not involve more thinking, depending on how much thinking you've already done under the existing laws. Slightly longer, a bit more detail as to what the changes are. There's a new accountability principle. They've introduced this idea of data protection by design and by default. Consent is significantly narrowed, at least from how it's been interpreted on the continent in the past. There are claimed to be new user rights. I'm not convinced any of these are actually new. They feel to me more like flavors of existing ones, but cover those in a bit. And there is a positive thing, there is positive in writing approval for doing security, that they finally seem to recognize that keeping systems, networks, files, data secure is essential if you want to protect privacy and data protection, but that those activities themselves involve processing personal data. So they have seemed to have admitted that, okay, there is a bit of a conflict there. To keep systems secure, you need to process personal data, and come up with extensions of ideas that were already in the existing telecoms law, the ePrivacy Directive, on how that balance can be sorted out. And my more than impression, I've written a full academic paper about it, and it seems that what they're expecting under the GDPR is actually quite close to good security and incident response practice anyway. So that's a positive win. So covering each of those in a bit more detail, the accountability idea is a bit of a transfer. You can see the old directive as saying, okay, we describe what processing we're doing, and it's then up to the individual user whether that's acceptable or not. Whereas under this accountability principle, on the regulation, the organization doing the processing is expected to both do more thinking about it and to be held responsible for if that processing isn't actually justified or is done for reasons other than those you've explained and things like that. So that involves understanding not just what you're processing, but why, where it's being processed, how long for, who, if anybody, it may be disclosed to. Yes, so answer the question, yes, the slides and a recording, I think, will be available, which gets a bit circular because the recording will contain the message that, yes, the recording will be available. Never mind. Also, organisations processing data are expected to look at the risks, not only to themselves as organisations, but the risk to individuals and how they are managed. Rather than, I've slightly crudely perhaps characterised the old system as encouraging you to produce information asset registers. What have we got where? The new one, I think, is about information life cycles. So why are we doing this? Where do we get the data from? How do we process it? When do we dispose of it? And how? And you're actually expected to look at the complete start to end life cycle. And more about how users can understand what's going on. It's also much clearer under the regulation that there are 6 legal bases for processing personal data, and those now more clearly require different information in notices, different duties of the organisation doing the processing, and to some extent engage different user rights as well. That's accountability. And also under accountability, if required, and the 2 categories are either public authorities or organisations whose core activities involve large-scale monitoring or large-scale use of sensitive personal data, then you're required to appoint a data protection officer with certain designated powers and certain designated independence. Universities that I've spoken to seem to have assumed that they fall into the second category, so that the process of awarding somebody a degree involves large-scale monitoring. So that one, I've not seen any discussion of whether universities need a data protection officer. I haven't seen any comment on colleges, but most universities seem to have just got on with it. If any colleges would like to let me know whether it's being assumed in that sector or whether it is a topic of discussion, give me a shout. Part of the accountability in some write-ups is this idea of data protection by design, and they say data protection by default. Data protection by design, anyway, is like, as a security person, I've always said security should be built in, it can't be added on afterwards. There's now the idea that data protection can't be added on afterwards, it needs to be built in from the start. So they're looking for evidence that data protection was considered early on in the system design. Can you have you thought about data minimization? Yeah, Colin, I think the public bodies is still an open question, because your public bodies for the purposes of freedom of information, which is a UK law, or FOI Scotland, Scottish law in your case, which there shouldn't be any read over from one to the other. The Information Commissioner does seem to be doing the read over, but there is a blog post on how to avoid that decision mattering, which, if we've got time, I may get back to. So, have you thought early in the design how little data can we use? Can we anonymize things? Can we use pseudonyms rather than actual names or any other sort of direct identifier? The other thing is called data protection by default. I think it's better expressed as privacy by default, but it's wherever any system or process has different privacy protecting options, those must be set by default to be the most privacy protecting. You can allow users to give away privacy, but you can't take privacy away and then say to users, "Oh, you can always tighten up your controls." The data protection by default I don't like, because that implies that you could just add or subtract amounts of data protection, which I suspect regulators would run screaming for if they realise what the text actually implied. So I'd tend to refer to privacy by default, but even regulators are pretty random in their use of the two terms, either privacy by design, data protection by design, or both by default. For risky activities, so large-scale processing or processing with significant effect or processing of sensitive data, then you may be required to do a formal data protection impact assessment. There is draft guidance out on this, though I've seen no sign of when that will be finalised, but it has a list of 10 characteristics of processing, and if your processing covers any 2 of those, then you may need to do DPIA. Again, it's about the risk to the individuals rather than the organisation, how you mitigate those risks, how you assess what they are. It's been suggested, and seems quite a good idea to me, that actually doing and documenting a DPIA might well be a reassuring thing for people whose data are in there, that you've thought about it. So I'd hope that this was something that organisations are motivated to do for the big scary things anyway, the major projects. At the moment in the regulation, this is written just to apply to new activities, but there seems to be an expectation that it'll cover existing systems too by 2021. Yeah, James, I'd have a look at the Article 29 draft guidance. It's not so much data, it's activities, it's what you're doing with it. And can an existing employee take on the responsibilities of DPO? Yes, and it doesn't have to be exclusive. It's pure. You end up, the limits are things like you shouldn't end up supervising decisions, supervising with your DPO hat on, decisions that you made with your non-DPO hat on. That would be not independent. So consent, something that has been used a lot. DPI is covering systems from the draft Article 29 guidance, if I remember rightly. Consent. A lot of this, I think, is actually what in the UK we've tended to do in the past anyway, borrowing the consent term from English. Sorry for the Scots. I think there is a similar understanding in Scotland that consent isn't valid or is presumed not to be valid, for example, if you're an employee being asked to consent to something by your employer. The law will always presume that there's actually pressure, either explicit or implicit there, and the employer would have to provide evidence that there wasn't. But this has now appeared in the text of the regulation, so consent must be a free choice, it must be informed, must be expressed by positive action. So all those forms, pre-ticked boxes, are going to be a bad thing to have after next May, I think. So for somebody to consent, they actually need to do something. You can't say they didn't untick the box. And possibly a challenge for some systems is that it has to be as easy to revoke consent as it is to give it. If you think you're relying on consent and your process can't cope with a user saying, it's Tuesday, I'm not having a good day, I withdraw my consent, then consent's probably the wrong basis. There's a couple of explicit things in there. Consent can't be made a condition of providing service. If data are required to provide the service, then process that under necessary to provide the service. You can't tie in, by using this service you also consent to X, Y, Z. That's got to be a separate decision. And it can't be done under compulsion. There's a phrase about where there's an imbalance of power between the data subject and the data controller. Also, if you're relying on consent, you're required to keep records. Who consented, when did they consent, how did they consent? One of the interesting ones will be to what. This seems to me to require you to keep a history of what your privacy notices look like. So that may or may not be a challenge, but when you need to be able to say, well, Andrew consented to this on such and such a date in 2018, and the privacy notice that he saw looked like this. Yes, the comment over there, task in the public interest, is very much, well, I would actually go partly as a data subject for legitimate interest, but that is very similar to task in the public interest in its requirements. The task in the public interest, where you'll trip up, is that the regulation requires you to, says that those tasks must be designated by law. So, if you're claiming public interest, you need to find a law somewhere that says this activity is in the public interest, which may be slightly tricky. Marion, yes. How long log files need keeping? Well, log files, logs of consent, certainly. That will be interesting. There is a case, it's a European case, is it YS, I think. There's a Dutch case where they looked at, okay, to protect, for data protection we have to keep these records, but since those records contain personal data, keeping them for a long time is a data protection breach. And that got up to the European Court, who basically said there should be a reasonable answer to this and kicked it back to the national court to work out what that was. If this sounds hard, that's because it's designed to be hard. There was a headline, lots of PR at the start about how this was going to reduce the overuse of consent. So you're likely to have to look at the other legal bases that we've sort of started discussing. And we'll get back to. So a quick trundle through the user rights. Information about processing doesn't feel new, though there may be some more information you're required to provide. Subject access, again, not new, though the ability to charge has gone away. The timescale, I think, has gone away, and you may be asked for a bit more metadata than under the current laws. Data portability, I scratch my head over. It's sometimes actually and most plausibly presented as competition issue. So this is, I'm tied in by my data to a particular social network provider. I wish to exercise my right to move all of my data to another social network provider. Unfortunately, it hasn't been just applied to large monopoly organizations, it's been applied to every data controller. So I think if you're a small organization, certainly our approach is we're going to treat this as a subject access request. It's limited because it doesn't contain all the data that a subject access request would, but in a digital format. The regulation says an industry standard structured digital format, and the guidance that the Article 29s have produced, I think, which has now has been adopted, it is final, on data portability, says that the industry standard structured format might be comma separated values. So they've suddenly come up with reality, I think. Rectification really puzzles me. Why wouldn't you want users to be able to tell you this data is wrong and please fix it? That one seems to be in everybody's interest, but it's one of the rights. Right to erasure, again, it's been plausibly argued that this one already existed under the UK Data Protection Act. If you've got no lawful basis for processing, since storing data counts as processing, if you've got no lawful basis for it, you should be deleting it. But it's expressed as a right. And it's still when there is no lawful basis for processing. Another reason for not using consent is that I withdraw my consent leaves you with no lawful basis, and you can be required to delete. Yes, indeed, deleting its processing, Tony. Right to object. Some of the legal bases, legitimate interest and public interest, allow an individual to object. This isn't to stop the processing happening. What's going on is those two bases require an overall assessment of risk versus benefit. And what the objection is saying, rather than the general risk-benefit assessment, I believe my circumstances are different, so reassess based on my particular situation. And if you reassess and you decide that, okay, in that case, the risk doesn't justify the benefits, you are required to stop processing. But it's not a mandatory stop processing. You can turn around in response to an objection and say, we have taken note of your circumstances, we have done the same, assessment and it's still by our count okay, you can appeal this to the Information Commissioner. And for the last three, so rectification of erasure objection, the regulation says, well, you might need a bit of time to think about, well, it doesn't say it, but recognises you might need a bit of time to think about these. So while you're thinking about it, the individual can say, don't do any processing so long as those requests are outstanding. And the final one, which again, having stared at the text, I think is an objection. It's a right to object to automated decision making. It's not a prohibition on automated decision making, though I've seen plenty of people saying it is. If you've got a fully automated system that's making decisions that have, the wording is something like legal or other significant effect on an individual, then the individual has a right to request that you, well, it's not really a request, it's a right to require you to reconsider that using a human rather than purely automated processing. Jethro, I don't think you would keep a record of the fact the data were requested to be erased. If you've got no lawful basis for processing, you've got no lawful basis for keeping a record. It's not blocking processing. It's not like, you know, I wish you to remember that I don't want to receive calls from you. It is simply a delete all record of me. And occasionally we have had to explain to students that deleting all record of them might have some harmful effects on their future employment prospects. So those are the rights. Right, security. As in the current Act and Directive, you must use appropriate organisational technical measures to protect data. The GDPR is more explicit and now says, for example, all sorts of good things: encryption, pseudonyms, authorization. So if you've got data, having only certain people can access it and they need to prove their identity and so on. It even mentions tabletop exercises for security breaches, which is great. This is all supposed to be risk-based and to develop as technology does. Again, fair enough. One thing that is new here is there's a requirement to notify security breaches. There's actually three, it recognises three kinds of security breach. There's a breach that doesn't put the rights and freedoms of the individual at risk. Those you need to keep a record of. If there is a risk to the rights and freedoms of the individual, you need to report this to the regulator. And the expectation is that you'll do this within 72 hours of discovering the breach, not necessarily of the breach happening. Expectation in the sense of if it's more than 72 hours, you're required to provide a written explanation of why. If there's a high risk to the rights and freedoms of individuals, and the example that's been given of this is credit card data, then you're required to notify individuals. There's no fixed limit on this. It says without delay, and that seems to indicate the sensible thing that you can talk to the regulator first to find out what they think of what you've done, what they think of how you've mitigated, whether they think this needs a notification to individuals. And as I mentioned earlier, there is very positive support for security and incident response. So, ways of dealing with this. Security and user rights we've talked about before. A little bit more on information life cycles and the legal basis, which we've been talking about. Life cycles, I think you need to look at why we've got the information, what for, and the whole history through time. Where does it come from? Do we get it direct from the individual? Do we get it from a third party? How do we process? Do we transfer it? Which I'm thinking of as a situation where it may be transferred internally to a different process, it may be transferred externally, but to somebody where we continue to share responsibility. As against disclosure, which probably the one we're most familiar with, certainly one I'm most familiar with, is disclosure to law enforcement under Section 29 of the current Act, where once it's disclosed, it's law enforcement's issue. So the responsibility ends, we are still responsible for whether or not the disclosure was lawful, but what happens to the data after that is somebody else's problem, and then deletion. So it's thinking about how information flows in some sort of digital version of space and time. But looking at this all looked very familiar because we've spent a lot of the last several years implementing ISO 27001, and this is very similar to the information you need for those, also for ISO 9001, the quality standard. So if you're using one of those standards, you may already have the information life cycles. If you're not using these standards, then at least the information life cycles should have subsidiary benefits. So you should find that it's helpful for information security, helpful for quality of whatever processes you're discussing anyway. So yeah, one of my ideas that when you're looking at the information life cycle, if you think back to the breach notification, it feels relatively natural to think, while we're thinking through the information life cycle, what could go wrong, how damaging is this, would this need to be reported to just the information commissioner or to individuals, and to sort of sketch out what that process might look like, because if you've only got 72 hours, you want to be as efficient as you possibly can and have done as much thinking as you can beforehand. Legal bases, these are the 6. 5 of them start with the word necessary, and that's necessary for contract, which I see Rachel has just mentioned. So we have some sort of agreement with the individual, and in UK law, a contract does not have to be in writing. A contract is any sort of agreement on a service where there's an expectation, understanding that failure to provide that service might be legally enforceable. So if I promise to send you a postcard from my next holiday, that's probably not a contract, but it doesn't have to be much more heavyweight than that. Certainly there has been a contract. Some of the lawyers on this will correct me if I've got the facts wrong, but a contract of if you if you push this bed from here to there, then you can own it. That was held to be a contract that was legally enforceable. So I think a lot of things will go into that, as long as the processing is necessary. Then 3 that I'd expect to be secondary for education, so necessary for a legal duty. Some of them are, as employers, we have to report national insurance, tax, things like that. Necessary for the vital interests of an individual. We'll probably come across those from time to time, but they're unpleasant situations where you try and minimize processing anyway. But that's things like you have found an unconscious person, you know they are allergic to a particular drug, you are allowed to tell the ambulance man, don't, or the doctor or whatever, don't treat them with that one. Public interest is almost entirely undefined. If anybody's found any documentation about public interest, let me know. There was a brief discussion by the regulators where they suggested that public interest was helping somebody else to fulfill their legal duty. So the tax office have a legal duty to collect taxes. You are helping the public interest if you disclose your information about a tax fraud to them. So there's no legal obligation on you to do that. This predates money laundering legislation. But it was this helping somebody to implement the law. That's the only discussion of it I've found, and that's from many years ago. One that I expect we will be using quite a lot is legitimate interest. The regulation itself identifies this as the right one for security, for example. And I think a lot of things around processing personal data to improve our services, whether that service is not delivering lectures at 9 o'clock on a Saturday morning, I was that student, or whether it's having books in helpfully shelved in libraries, things like that. I think those ought to be fitted under legitimate interest, because legitimate interest requires you, before you do the processing, to assess the risks and balance your benefit against the risk to the individuals. Then there's consent, and all this stuff about not as a condition of service, not under pressure. I'm almost starting to wonder if consent can only work where information is not necessary. The text of the GDPR doesn't go quite that far, but I'm almost applying a rule of thumb of if I provide false information here, does the system break? Yeah, Helen, I will show that slide if I've got time, since it's come up a lot. How to do legitimate interest. You can. The regulation is explicit that public authorities can use legitimate interest for security, if nothing else. No, legitimate interest of the organisation, Ian. I'll get to that. I'll get through these slides and then we'll do that optional one. These 6 have, say, different duties, rights, notice requirements for each. The ones I've put in bold, I think, are the ones that we're likely to be building into our processes routinely. Sometimes, quite often, you've got an activity that's complex where you may need more than one. So if you want to subscribe to my blog to get email notifications, we need your email address. I can't send you an email notification if I haven't got your email address. So that's necessary for contract. Then there's the security thing, so we will keep a record of people who use the subscription interface, accounts, IP addresses that use the subscription interface, to look for suspicious patterns of use. Is somebody signing up a third party to receive a flood of announcements that Andrew has done another blog post? If you're thinking of that, find a busier blog. And then, if you want to be addressed by your nickname or something, rather than user number, this, that, and the other, or you want to have a picture on your account page, whatever, there I think that is genuinely free. So that I would suggest was consent. So that's a fairly typical pattern, I think, where there's the essential stuff for both of us, contract, there's the stuff that we need as the provider, which is legitimate interest, and there's the stuff that you want, which is consent. So, organisational issues. Oops, I said 40 minutes, didn't I? Never mind. I think there's only a couple more content slides. The Information Commissioner published a document a while back on 12 steps to GDPR. And I then sort of did the project management stuff on these and sorted them into some sort of order. So the basic requirements of how you're going to appoint a data protection officer, do you need one, and who's your national regulator, which law do we actually have to deal with. Then there's 3 kind of fundamental processes, either in the case of the information lifecycle audit because everything else depends on them, or awareness raising and data protection by design because they're going to take a long time to implement. So these are the 3 that I'd really get on with if you haven't already started. Part of those I've suggested maybe the data breach notification. As you do the information life cycles, you should pick out why are we processing that, gives you a lead straight into the legal basis. Legal basis tells you what needs to go into privacy notice. If you're using consent, then what does my consent process look like and my revocation process? There's additional stuff if you're trying to get consent from children. I would phrases involving barge poles and consent from children. When you look at the GDPR, I would really try and stick to stuff that's necessary under one of the other 5. And then legal basis also drives what the individual rights are, one of which is subject access. Or if you want it in a project plan, this is the sort of picture I came up with. So the information lifecycle audit drives breach notification and the legal basis processing. Legal basis processing drives privacy notice, individual rights, and consent. So though the information lifecycle seems to be the really key one, that a lot of the other stuff, it's not quite handle cranking, but it's fairly automated once you've got those. Then finally, okay, Brexit. GDPR comes into force next May. Brexit at the earliest will happen the following March. So the GDPR will be implemented, will be UK law from the 25th of May next year. UK government have said this is a law that they are going to carry over in the, is it no longer great or no longer repeal? The Act anyway. ePrivacy may be more of a challenge. It was aiming for May 2018, but who knows when the council are expecting to have their views ready, so whether that one will be in before Brexit, I'm not sure. Once Brexit takes place, the UK will be outside the European Economic Area. So we will be in the same legal position as the US is now. So whereas at the moment we are presumed to provide appropriate equivalent protection, once we're outside we will be presumed not to provide equivalent protection. So all the hard questions that you're asking US service providers now, expect people on the continent to be asking you. So model clauses in contract, if you're multinational, probably doesn't apply to many here, binding corporate rules, having a representative within the EEA, etc., etc. And I think there will be hard questions about government access. So those were my slides. I think can you move to, yes, Edward can move to a point where I can actually pick and say, I want to look at that slide. I hope. Eek, where is it? Ah, right, I'm sorry. That's why I need to be sitting next to somebody who knows what they're doing. So the legitimate interest question. Yes, James Collin. I doubt that when an individual will be held liable by court, there's sort of a precedent in the various attempts to invoice people for copyright breach, where the organisation was basically a sole trader and went bankrupt, and they ended up actually the only thing that was left was the human. So is the public authority slide now visible? Sorry, Edward. Yes, it is, right. Except to me. I hope you can see it bigger than I can. I'll turn it. Yeah. Oh, there we are. That's better. I can read that. Okay. The public authority question. There's two definitions of. Well, no. There are two uses of the term public authority. The GDPR says that public authorities may not use legitimate interest in the performance of their tasks. It also says those tasks must be defined by law. So I turn that round and say, if the task you're acting on isn't defined by law, then you can't be a public authority. And actually the GDPR seems relatively clear to me that it's talking about situations where the law says you must do this. And if the law says it, then you're not allowed to use legitimate interests to expand that power to other things. And that, I say, to me seems relatively straightforward. The Information Commissioner has completely muddied this by saying, oh, public authorities is a term defined in the UK Freedom of Information Act, and the English, England and Wales and Northern Ireland Freedom of Information Act, and the Freedom of Information Scotland Act. I can't see any, in legal theory, there is no justification for taking a term from UK law. Please excuse divulge. People, please excuse my shorthand, and assuming that that's what Brussels meant. They almost certainly didn't. But what I'd suggest is, if legitimate interest looks like the most appropriate basis, so this is something that you are doing for the organization's purposes, like security. I am logging accesses to my website in order to detect when somebody is attacking the website, to discover when somebody's managed to get a virus on that website, who has downloaded it, and I need to help them, things like that. That is very clearly a legitimate interest. It's recognized as such by the regulation. So design for it, do the balancing test. Make sure that the way I'm doing this, the risk to individuals from my doing it is justified by the benefit that I, and in the case of security, they, because they are data subjects whose data are on that system, are going to receive from it. If there's an objection, either from the ICO, preferably from the ICO, on the basis of you're not allowed to use legitimate interest in the performance of your task, fine. Say, in that case, if I'm doing it in the performance of a public task, it must be necessary in the public interest. As a data subject, I really, really hope we're not forced to do that, because that removes the need for the balancing test and also reduces the amount of information that data subjects get. What I wouldn't do is go, oh, legitimate interest looks the right way to do this, but we're not allowed to use legitimate interest. Therefore, we need to get everybody's consent. Getting everybody's consent ain't going to work under GDPR anyway. And actually, there's also a little phrase in the regulation about how public authorities are unlikely to be able to get consent, valid consent anyway. So I've heard a couple of people saying, oh, because public authorities, we have to get consent for everything. I really, really wouldn't go that way. They're scrolling past awful quickly. Presumably each organisation may apply a number of legal bases to different functional information types. Absolutely, Colin. I think probably less so information types unless you're getting into sensitive personal data, or as it's now called special category data, where there's actually a different set of legal bases. But there's the example a couple of slides back of where running a website and taking subscriptions involves at least 3 of them. We've now got lots of questions around the log. Are there any others I need to scroll back to? Slides, feedback form, fines. I think we covered, but yeah, in theory, the GDPR allows the ICO to fine up to 20 million euros or 4% of your global turnover. I think that's highly unlikely. Example I picked up on Friday. Now, what was it? A local council had a system whereby people in need of care, you're kind of putting together people in need of care and care providers. So the care providers want to know, can I provide the sort of care that person needs? So the council had put on a website, person A, following characteristics, this age, so on and so on. Plenty, didn't actually include name or rough area where they lived, but plenty of information there for anybody who knew them, certainly, to identify them. So the providers could go on and say, yes, we can support that person, we can support that person, we can not support that person. 5 years later, somebody outside said, wouldn't it have been a good idea to put a password on that website so it didn't get indexed by Google? And that council have just been fined £70,000 only. Which, if they're not pushing the limits of the current fining powers, I think it seems highly unlikely anybody else will. Backup tapes containing our annual archive data, are they backups or are they archives? There is a blog post from way back when about this. A backup tape, to my mind, is something that you will use when a system goes bang. So actually you only ever need one of those. Possibly a few of them, because a system might go less explosively bang, so you don't know how far back you want to go. But it's really up to you. How long after the user accidentally deletes a file do you want to be able to recover it for them? Whereas an archive is the institutional memory, so is not all the data we have. And actually, a backup is an awful format for an archive, because you need an archive should be structured as to why is this a record. So a backup tape, I think you would. I can't remember. I didn't see when this came up. A backup tape, in terms of retention times, you should know how long you're going to keep backup tapes, and then you overwrite them. If you're saying if a user exercises their right to erasure, would you have to go through the individual tapes? I think the ICO's guidance on that so far has been no, that it's just too much hassle. Mechanisms to benchmark maturity. The ICO's just published one, actually, in the last couple of weeks. So have a look on ico.org.uk. Proper definition of public authorities. I suspect we're not going to get one, John, because my slide up there, it doesn't actually matter. Yeah, the ICO has been, I won't say flailing. The ICO has had a number of different views on this, sometimes simultaneously. At the moment, they mostly seem to be saying hybrid authority. which is another term borrowed from an irrelevant piece of legislation. It's from human rights stuff. But they seem to want to say, well, yes, some of the activities may count as public authorities, some will not. They're stuck with the fact that keeping security doesn't. So I suspect, as I say, this is why I'd go with the suggestion on that slide, and there is again a blog post on it, that design for legitimate interest, then if needed you can switch to public interest. Pseudonymized data, yes, definitely still personal data and in scope to BRE Bray. The treatment of pseudonymized is very weird in the regulation. It's recognized as a good measure to protect security, but it doesn't actually get you any brownie points or get you off any obligations. There is a clause that says if you've only got pseudonymized data, then the regulation, so if I've only got IP addresses and website logs, I have a data breach, which suppose it's as serious enough to require notification of individuals, I can't do it. I cannot proactively contact somebody for whom I only have an IP address. And the regulation says if you can't do something, then the regulation doesn't create a requirement for you to keep the data or to collect the data. You would need to be able to do it. So if you can work with only collecting pseudonymized data, do. That is a good thing. It's then unclear, and I wrote my master's thesis, one of my master's theses on it, what happens to subject access if you've only got pseudonymized, because there's no way you can actually check the identity of the individual. Consent, legitimate interest. No, sorry, John, my comment wasn't that way round. It was, there are many instances where legitimate interest is the right justification. I think anything where you want broad acceptance is wrong. Where you want to process most people's data, or indeed everybody's data, consent is wrong, because you won't get it. So legitimate interest, as far as I remember, can't be used for sensitive personal data. So you would need sensitive personal data. I think you either need a legal permission, so either legal duty or public interest, or consent. So I don't think legitimate interest is actually available. I'd need to check that. It certainly isn't under the current law for sensitive. Right, to my facilitator, since we're now at time. I can keep answering questions if you're happy for me to keep answering questions. 5 minutes. Okay, 5 minutes. 5 minutes. Data protection officer role. The Article 29 guidance is actually quite good. Not so much in saying where it should sit, but saying what access it needs. So it certainly needs access to the senior management team. Does it need to report directly to them? Not clear. It needs to be sufficiently senior that it is taken seriously by the senior management team. But there's also, they talk about independence, and I see that as being kind of upstream independence, so you need to be able to speak truth to power. And there's also downstream independence, so you shouldn't be overseeing decisions that you yourself have made. All right, somebody's found the blog. Good. GDPR impact on ethics for research, it's one of the derogated areas, so no. Sorry, waiting to see what the Department for Culture, Media, no, sorry, Department for Digital, Culture, Media and Sport, they got an extra D, come up with for that one. There's essentially no GDPR statement about research data. It says countries should do this, which is horrible because most research happens not in a single country. Legitimate interest in sharing with the student union, you need to apply the balancing test. I know there's been a lot of discussion about that one. Whose legitimate interests? If you can share with the student union in such a way that the benefit of that sharing to the university is not overridden by the risks to the rights and freedoms of individuals, then student union might work. John, I'm not sure how would that work with HR data. Most HR data is processed as necessary, either for contract or for a legal obligation. Sorry, things are scrolling too fast. Those who have to leave, yes, please do. We were scheduled to finish 4 minutes ago. Template guidance for completing a DPIA. There is the... oh, thanks, Edward. We're trying to wind up and you encourage people to post more questions. Template guidance, so there's the Article 29, I think it's draft still guidance, and they explicitly mention the Information Commissioner's various stuff on what the Information Commissioner called privacy impact assessment, one of the examples where the term is used very fuzzily. So I'd look at those. The critical thing about a DPIA is it's the risks to the individuals, not the risk to the organisation. Oh, and LT is about to be swamped with requests.
Okay, everyone. Thanks ever so much. We've run over obviously by 5 minutes, so I was just giving a bit of extra time there for a few more questions post past. But I know everybody has to dash off, obviously for lunch or for your next meeting. So yeah, thanks ever so much for your. In order to leave the session, all you need to do is just close your window or tab, and that locks you out. And yeah, just leaves us to thank Andrew very much for his really informative session on GDPR. Hopefully, you've come away feeling a lot more informed about the subject and a lot more kind of informed generally. So yeah, thank you to Andrew, and thanks to everybody for attendance. I hope you found it beneficial. As I say, just close your tab or browser window, and that locks you out. So thanks a lot, guys.